Welcome to Rock Center Shorts. I'm Kristen Savell, Managing Director of the Rock Center for Corporate Governance at Stanford. Today's guest speaker is Amy Caiazza, a securities, fintech, and blockchain partner in Wilson Sonsini's Washington, D.C. office and leader of the firm's fintech and financial services group. Amy advises clients on regulatory and transactional matters involving the securities and commodities laws and was recognized as a 2022 FinTech Trailblazer by the National Law Journal. Welcome, Amy.
Thank you. Thanks for having me.
Thank you for being here. Today, we're going to talk about a sample comment letter that the SEC released on December 8th that provides guidance related to companies' disclosure obligations in light of recent developments in crypto asset markets. To start things off, can you give us an overview of the comment letter and the guidance it provides?
Yep, I'm happy to do that. At a really high level, what the SEC is asking for is that public companies provide detailed and tailored disclosures that are related to events and developments in the crypto asset markets that discuss the company's exposure to potential risks or potential events in the crypto asset markets, and that discuss how investors might be impacted to the extent that those developments are relevant to understanding and assessing, a company's operations, its financial condition, and its share price. The SEC doesn't really provide particular issues that any particular company will need to address, but it sort of holistically says that public companies should be considering what types of disclosures they need to make. And the SEC also provides a sample comment letter, as you said, that discusses the types of comments that a public company might be expected to receive based on what's going on in the crypto asset markets.
Right. So you mentioned public companies. What types of companies should be paying attention to the guidance? Is it only public companies? Is it broader than that? Is it only crypto native service providers and issuers?
Yeah, it's a really good question. So yes, this guidance is really targeted at public companies. It's not at public companies that are listed in the US. It does not apply to private companies. And I think that's an important point, given that, some of the bigger actors that have had seismic events over the past several months have been private companies. And so an FTX, for example, wouldn't have to make the kinds of disclosures that are discussed in this guidance. It's probably broader than companies that just have direct exposure to the crypto asset markets. Obviously, a company like Coinbase, for example, a public company that's active in this area, would need to consider the guidance. But other companies, for example, companies that might be dipping into blockchain as a technology, as an asset manager, or in some other way, shape, or form, like a JP Morgan might be affected. Companies that are issuing NFTs, like a Coke, for example, might be affected and might need to consider the guidance. And companies that have significant holdings in Bitcoin or other digital assets probably need to consider the impact of the market. So it's just public companies, but it's potentially relatively broad spectrum of public companies. And separately, although private companies are not directly affected by this guidance, they do need to disclose to their own investors, material events and material conditions and risks that they're exposed to. And so they may look to this as a more kind of a guiding set of principles, but not necessarily as technically applicable to them.
Great, that's super helpful. So the SEC's comment letter asks companies to disclose any significant crypto asset market developments material to understanding or assessing their business, financial condition, and results of operation. That's language that's taken from the comment letter. What are some examples of significant crypto asset market developments that might trigger a disclosure obligation?
So obviously the events of last November or so, where you have a major exchange that is kind of unwinding and falling apart, would be an event that could affect a lot of different companies, particularly companies that have exposure as counterparties to an FTX, say. There are also going to be related situations like the bankruptcy of Celsius and BlockFi that would, again, potentially directly affect a variety of different public companies. I think down the line, if you think about it, the type of volatility that's occurred in the markets as a result of some of those events, and as a result of just sort of a general declining value of digital assets over the past year or so, will affect a company that, for example, has significant holdings in digital assets. It could also affect liquidity in the markets, and that could affect the ability of a company to access cash when they need it. Finally, to the extent that a company has adopted blockchain or issued an NFT or done something like that in the blockchain space, if that's a material part of their business, they need to consider whether just a disruption to the markets generally is going to be relevant to what they're doing, their liquidity, and their financial operations. And so, again, harkening back to a company like Coke that's issued NFTs, a decline in the crypto markets could affect the viability of those NFTs. On the other hand, if that's a pretty small part of their marketing budget and of their commercial operations, it may not be something they have to talk about in any detail, if at all. The point is, think holistically about your exposure to these markets and how it might affect operations and financial stability.
Do you think the guidance reflects a change in disclosure policy, or does it just make clear what companies should have been doing already? And if the latter, why do you think the SEC chose to release this guidance now?
It's another really good question. In theory, and really in practice, any company that has this type of exposure should have been making these disclosures on an ongoing basis. That's part of the point of public disclosures for public companies. They should be considering any kind of material development. On the other hand, I think the SEC may have been thinking about a couple different points in providing this guidance. One is that historically, over the past few years, we've seen a real disconnect with what the SEC says and thinks it's saying and what the industry hears. And I think that the SEC is probably thinking about that and wanting to very much ensure that companies in this space and actors in this space are very clear about the types of issues that they should be disclosing. In other words, the SEC is just trying to be crystal clear that this is something that companies should be thinking about. On the other hand, it may also hearken towards additional guidance that we're going to get in a wide variety of areas, including outside disclosure, more substantive areas like what does an exchange have to do in order to comply with the substantive securities laws? How can they register as an exchange or as a broker under the securities laws, which are really big, sticky issues that we are still waiting for a lot of guidance on.
Okay, since you raised some of those issues, let me jump ahead a little and ask you, because we've seen this guidance on disclosures, and we've also recently heard renewed demands from Gary Gensler, chair of the SEC, and other members of the commission staff for crypto exchanges and other intermediaries to register and I'll use their words, come into compliance with existing rules. What do you think this portends in terms of SEC regulation of the crypto assets industry?
Another really good question. I think it probably does, especially with all those other tea leaves that you cited, suggest that we are really moving towards some additional guidance by the SEC and its staff around these types of issues. As you said, the regulators have, including the SEC, have really made a lot of noises recently that type of guidance is imminent. And I think the disruptions we've seen in the markets are probably inspiring them to act as quickly as they can. So I do think we will probably start to see more specific guidance around, how is it that an exchange can register with the SEC? How does it deal with the customer protection type issues that we don't have a lot of guidance about what a broker should do to comply with? That said, I'm going to say I've thought that this guidance was coming for quite some time, and so I could be wrong. It may not be quite as imminent as I would like it to be, but I do think for the sake of the markets, it would be really great if we were getting more guidance along these kinds of lines, outside of just enforcement, by the way, but substantive guidance that would allow companies to come into compliance where they have questions about that.
Right. So how important do you think this guidance is on its own in the absence of a more clear and comprehensive regulatory framework for crypto assets, or at least guidance on specific issues like custody or classification of assets, to name just a few of the many issues that remain unresolved?
I think relative to those issues, this is a pretty small drop in the bucket. And as you referenced earlier, probably very clearly things companies should have been doing already. There's nothing particularly seismic or revolutionary about what's said in this guidance. And so in the absence of other more substantive guidance, it's probably not all that helpful. To the degree it portends additional guidance is coming down the pike, that would probably be the area in which we, looking back, say that it's a significant step.
So I guess to push back on that a little bit, I will say the guidance purports to focus on disclosure obligations under the federal securities laws, but it seems like it actually does more. So for example, companies are encouraged to disclose to the extent material gaps their board or management have identified with respect to risk management processes and policies, any policies and procedures they have in place regarding the commingling of assets or prevention of self-dealing and other potential conflicts of interest, any steps they take to safeguard their customers' crypto assets, and any material changes they have made to these processes and policies in light of recent disruptions in the crypto assets markets. So most companies aren't going to want to disclose information about policies that are clearly deficient. So I guess I'm wondering, is this a roundabout way of forcing companies to shore up some of their conflict, compliance, and risk management processes and policies?
It's another really good question. So I think that you're correct that the SEC is pushing companies towards some more substantive changes to how they're doing things, potentially. At the same time, I think the kinds of things that are referenced here are also the kinds of things that a public company should probably be doing already. Anytime a company is considering a new business line or considering dipping its toes into new technologies, those are the kinds of risk management decisions and discussions a company and its board and its management should be having anyways. And so I suspect that, harkening back to our earlier discussion, this is a way of the SEC reminding companies and making sure it's crystal clear that this, like any other business area, is subject to the federal securities laws, subject to general corporate governance provisions and state laws around fiduciary duties. And so companies need to make sure that anything they're doing in the crypto space is just as compliant and just as considered and runs through the traps in the same way that any other type of new business line or investment line or commercial operations should be. So you're right. I think it's bigger in the sense that it's pushing companies to consider those issues, but those are also issues that any company in this space should be thinking about as they're involved in it, given the newness and the volatility and all of the other pieces of the space that differentiate it and make it new and exciting, of course.
Okay, last question. The list of issues that companies should consider disclosing in light of the guidance is quite extensive. So I'm curious how you would advise companies to respond to the guidance.
So I think companies need to think holistically about what they're doing and how it fits in with the guidance and what kind of exposures they have. And so, yes, if a company is operating in the blockchain and crypto space, there's no question that many of the list of issues that the SEC cited in its letter would need to be a part of how it thinks about its disclosures. On the other hand, if you have a company, again, if it's just issuing an NFT, it probably doesn't have to worry about things like, does a stay on redemptions by a Celsius affect its ability to operate? Where a company really does have, say, liquidity issues or as a counterparty to one of these players that is the subject of seismic events, they do, in fact, have to make those disclosures. But for the vast majority of public companies, it's probably going to be a relatively limited piece of guidance. I think the way we think about this is the way we think about any other public company disclosure. There may be lots of theoretical issues they need to think about, but they really only need to focus on those that are actually relevant to their business model. And so there's a more principles-based thought process around what those disclosures need to look like.
Great. We will wrap things up here. Thank you so much for taking time to join us today, Amy, and for sharing your insights with our audience.
Great. Thank you for having me. This was really great.